Ladies and gentlemen, today I immerse into the, in my opinion, very intricate internship between European Union and European Union law and our national law in Poland. I will want to shed the light to the concept of UA law taking precedence over our national law. I would like to say about its implications and our Polish perspective on this matter. Firstly, the principle of primacy, also known as you may know as the supremacy principle, is one of the fundamental principles that define the relationship between the European Union law and national laws of member states. It was developed through decisions made by the Court of Justice of the European Union, and this principle is crucial in determining that UA law takes precedence over the national laws of member states. In simple terms, it means that if there is a conflict between UA law and national law, UA law must be applied and followed. And my question is that if it is really absolute, is it really in any case the first one to imply, and it only prevents the application of conflicting national laws, but also prohibits the enactment of every new national laws that contradict the UA laws, of course. And however, it is important to note that the primacy is based on the idea that conflicting national laws should not be applied, rather than invalidating them altogether. When there is a conflict, it is the responsibility of the national legislator to amend or remove the conflicting national laws to ensure they comply with UA law. The CJUA doesn't have the authority to declare national laws invalid, of course. This falls within the jurisdiction of the national legal system. So when discussing the principle of UA law supremacy over national law, we need to consider a whole acquis communautaire. So I mean that the both primary sources and secondary sources. So firstly, treaties establishing the legal framework of UA legal order, and secondly, all the instruments, all the acts and sources encompassing legal instruments based on these treaties, such as regulation, directives, and so on, as well as my third point, all general principles of UA law and CJUA case law and international law, and so on. To base these two legal systems, we rely on conflicts of rules, and it depends to which source we have to indicate that. And primary law becomes part of the national legal order, and is directly applicable except when specific legislation is needed. If such legislation is adopted through the major ratification procedure, it takes precedence over the national law in case of conflicts. And secondary law is directly applied and predominates in conflict as well, but regulations are directly applicable, while directives require implementation through national legislation, of course. In general, UA law holds the status of it holds the status of the law, of course, and takes precedence over national law when we have conflicts. UA law serves as a tool to achieve the common goals and values of the European Union, because such as freedom, as security, such as justice, it forms the legal foundation of the European Union's operations, notably UA law and national laws of member states share common values, as it is stated in Article 4 of European treaties. And the adoption of the primacy of the European legal system carries significant consequences. It will be in a second. Significant consequences like it ensures consistency in application across the UA. It's crucial for the functioning of common market and its efficiency. Secondly, it safeguards the rights of citizens, businesses through the whole European Union, and guaranteeing uniform level of the legal protection as well. Thirdly, it also grants the European Court of Justice the authority to interpret and apply European Union consistently through the Union. Essentially maintaining a unified stance of legal matters. In principle, EU law takes precedence over national law, but we have these two perspectives: the perspective of the European Union and the perspective of member states. So it's really also important to recognize that this principle doesn't render national law irrelevant, of course. In Poland, this hierarchy of legal sources has sparked debates and primarily are revolving conflicts between the founding treaties and the Polish constitution, especially. These concerns revolve around the compatibility of the Republic's legal obligations under the founding treaties, the acts adopted by UA institutions, and the ruling of CJUA with Article 8 of our Constitution, which upholds the Constitution's supremacy and its direct applicability. And from the perspective of Poland's national legal system, we have both laws and regulations that apply across the board. When it comes to UA directives, the indirect impact mostly kicks in after the deadline for implementing them is passed. And from that point, courts in UA member states must interpret the law in line with UI rules. At the same time, the authority, I think, the law should avoid interpretation that go against the directive, starting from when it becomes effective and continuing until the deadline for implementation is done. There are, of course, limits to a pro-European interpretation of the law. They are essentially determined by general principles of law, such as principle of non-retroactivity of the law, the principle of legal certainty, of course, and inadmissibility of an interpretation control organ. It's important to note that some experts in Poland see a potential problem with UA law directly affects national law. It could lead to different interpretations of the same situation by courts in the different member states or even within the same country. That's why some suggest that UA directives should have more direct impact at local basic level. Some legal scholars are not entirely happy with how UA law indirectly affects national law because it involves courts in what they see are legislative or executive tasks and duties. Furthermore, the recognition of the supremacy of the external legal system over the Constitution has led to concerns about limiting the sovereignty of national of our Polish nation, and as outlined in Article 4 of Constitution, this raises questions about the admissibility of such limitations. Poland's UA membership is grounded in Article 19, which I show you on my PPT. Often it is referred as the pillar of Polish European Union integration. And while this article doesn't explicitly mention the European Union, it refers to an international organization or international body, reflecting concerns about safeguarding the Republic's independence. The article provides a basis for transferring certain state competencies to such entities in specific matters, such as when the same relinquishes its authority to regulate issues already covered by international law. However, it is also crucial to understand that transferring competencies doesn't imply the loss of state sovereignty. These transfers occur through treaties which must be ratified with the prior consent of the nation in a referendum or by the same through legislation. And the choice of the ratification path is determined by the same, requiring an absolute majority of votes. Article 9 of the Constitution further obliges Poland with international law, to comply with international law, upon it further emphasizing the nation's commitment to international legal orders. Nonetheless, it's worth emphasizing that the European Union is not a sovereign state. Of course, it's a unique legal entity and lacking the right of competence, so it only UN member states possess. So additionally, the transfer of competencies to UA bodies is subject to judicial oversight by our constitutional court, and the constitutional courts of other UN member states, as we can could hear in the previous presentations. And I prepare for you our constitutional judge, constitutional court's judgment, key 80/04. It illustrates that the UA law doesn't always take absolute precedence over national law. According to this ruling, Poland retains the possibility to withdraw from the European Union if an incompletable contradiction between our constitution and UA law emerges. The decision to withdraw with Poland is Poland's jurisdiction, not the European Union jurisdiction. Based on this article, a comprehensive legal framework was established, covering accession and the potential for withdrawal from the UA. So, we have 3 steps in this case. So, firstly, mandatory renegotiation of the European Treaty. Secondly, amending the Polish Constitution, if it's not enough. As last resort, withdraw from the European Union. The Constitutional Court's position is that neither Article 90, Paragraph 1, and nor the Article 91, Paragraph 3 can provide basis for delegating authority to an international organization to enact legal acts or make decisions that contravene the Constitution of our republic. Particularly, these norms cannot be used to delegate authority to an extent that would undermine Poland's ability to function as a sovereign and democratic state. And furthermore, the Constitutional Court in its next ruling distinguished between the primacy of application and the primacy of validity. It stated that the principle of the nation's supremacy in Article 4 allows for the primacy of applying UA law over the Constitution of the Republic of Poland. But this doesn't apply the supremacy of UA law over the Constitution in case of in second case. So the court also introduced the concept of constitutional identity, defining it as an immutable set of values and legal principles fundamental to the country. These principles cannot be transferred into national bodies. This evolving concept of sovereignty, as defined in Article 4 of the Constitution, inadequately reflects Poland's role in European structures today. This constitution retains ultimate power and priority in terms of validity. However, it permits under certain circumstances and with its consent the priority of directly applying international law. In essence, the culmination of the argument is the recognition that EU law doesn't enjoy the absolute precedence over our national law, only the robust standing for states' fundamental legal government. In my conclusion, Poland's relationship with European Union is multifaceted, involving a delicate balance between sovereignty concerns and integration requirements. While UA law enjoys priority in application, the Constitution maintains supremacy in terms of validity, ensuring Poland's status as a sovereign and democratic state. That's all for me. Thank you very much for your time.